I'm Dr. Kalpana. Today, in this lecture, we would be discussing building blocks of labor law. Labor law in India is a complex and evolving field designed to balance economic efficiency with protection of workers' rights. Its applicability varies significantly based on the nature, size, and type of work performed in an establishment. Understanding these distinctions is crucial and important for comprehending the scope of labor regulation across the nation. Defining the workplace in Indian labor law, which is the biggest challenge, broad interpretation has been given by the court. Term workplace generally refers to any premises or site where work is carried out under a contract of employment or where workers perform tasks related to their trade or profession. This broad definition ensures that various environments, from traditional factories to modern digital offices, are considered. Diverse categories are there: factories, shops, commercial establishment, mines, oil fields, plantations, construction sites, transport undertakings, offices, including remote and digital. Key labor laws and their applicability. Factories Act 1948 just came after India got independent. Applies to manufacturing premises with 10 plus power and 20 plus no power workers, regulates health, safety hours, welfare, and leave. Shops and Establishment Act, state-wise laws for commercial establishments, offices, shops, hotels, governs working hours, holidays, wages, and employment conditions for non-factory workers. Mines Act 1952 covers underground surface mines, ensures safety, health, regulates working conditions for mine workers. Plantation Labor Act 1951 applies to plantation within 15 plus workers, tea, coffee, rubber, provides welfare measures like housing, healthcare, and education. Specific regulations for contract and construction labor. Contract Labor Regulation and Abolition Act 1970 applies to establishment employing 20 or more contract laborers. Its purpose is to regulate the conditions of contract labor employed by establishment and contractors, ensuring fair practices and preventing exploitation. Building and Other Construction Workers Act 1996 covers workplaces with 10 or more construction workers. This act provides essential welfare, safety, health measures, especially tailored for building and construction workers, addressing the unique risk of industry. Industrial Dispute and Wage Uniformity. Industrial Dispute Act 1947 applies to industrial establishment, including factories, mines, plantations, certain services. It provides mechanism for resolving disputes, regulating layoffs, retrenchment, strikes, aiming to maintain industrial peace. Code on Wages 2019, a modern legislation under new labor codes applicable to all establishment and employees across sectors unless explicitly exempted, its primary purpose to ensure uniformity in wages, timely payment, and eliminate gender-based wage disparity. Now coming to public versus private sector labor laws. Public sector government departments and public sector units are regulated by general labor laws but also by specific service rules and constitutional procedures, Article 309 to 311, ensuring additional safeguards for government employees. Private sector primarily regulated by central and state labor legislations and relevant industrial acts. These sectors Regulations focus on employment conditions, wages, dispute resolution within private enterprises. Formal versus informal sector workplaces. Formal sector, well documented establishment covered by majority of traditional labor laws, ensuring structured employment and benefits. Informal sector, typically small, unregistered units, for example, home-based workers, domestic help, gig workers, largely uncovered by traditional laws, but increasingly a focus on social security reforms like Code on Social Security 2020 would try to help out these gig workers. Addressing emerging workplaces, gig and platform work. Traditional gaps. Workplaces like Uber, Zomato, Swiggy, Ola, freelance platforms, remote work environments are not fully covered under traditional labor laws, posing new challenge for worker protection. New legal frameworks, Code on Social Security 2020 attempts to bring gig and platform workers into the fold of welfare benefits, recognizing their unique employment models. Evolving landscape, the dynamic nature of workplaces demands a proactive legal system that adapts to emerging forms of employment while retaining core principles of labor justice and equity. Now, I would like to conclude here. Understanding the types of workplaces covered under India's labor law framework is essential for applying the right regulatory mechanisms to safeguard workers' rights, ensure employer accountability. As economy evolves, so must our conception of what constitutes a workplace to include digital, flexible, home-based work environments. This dynamic nature of workplaces demands a proactive legal system, one that adapts to emerging forms of employment while retaining core principles of labor justice and equity. With this, I would end here. Happy learning.